So the next question was asked in 2014. So let's see the question. The question says, which of the following is or are the functions of the cabinet secretariat? So the question is basically from the administrative part, administrative part, administrative part, and in that it is from the permanent executive. Permanent executive, that is civil servant. Civil servant. Now, before answering this question, cabinet secretariat, let's see what the cabinet secretariat means and what are its functions. So when we talk about a cabinet secretariat, so let's write cabinet secretariat as a CS. So cabinet secretariat is a staff agency, we can call it staff agency to help the cabinet and its ministers to deliver their respective functions, right? This cabinet secretariat is similar to that of a central secretariat. The difference between the cabinet secretariat and central secretariat is that central secretariat is a staff agency to the whole council of minister, right? And we have already seen and you already know that the council of minister consists cabinet minister, then minister of state with independent charge, and deputy ministers. So this central secretariat is helping or functioning as a staff agency for the council of minister as a whole. And we also know that the cabinet minister in council of minister are the highest law making and body, deliberation body. So there is a specific agency, staff agency known as a cabinet secretariat. Now when the cabinet secretariat meets, so it has a two head or chaired by two personality. One is a political head. So politically the cabinet secretariat is headed by prime minister, whereas administratively it is headed by a cabinet secretary. Cabinet secretary, which is a highest IS officer or administrative officer of India. So this is some background related to cabinet secretariat, right? Now if you see the functions which has been asked under the cabinet secretariat, so if we go through the functions, so first function says the prepare of agenda for the cabinet meeting. Yes, it chaired the cabinet administratively. The meeting has been chaired. So this is the first option, so it's correct, right? But to answer this questions, this is a factual question, so you need to know the facts about this questions. Then secretarial assistance to cabinet committees. Yes, it is being a staff agency, so it helps us secretarial assistance. So this is also true. So 1 and 2 is true. So this and this can be our answer. This cannot be the answer. Now if you see the third, allocation of financial resources to ministries. So does the cabinet secretariat has a power or duty to allocate financial resources? No, this is not a power or this is not a functions with which is assigned to the cabinet secretariat. So 3 cannot be the answer. The third statement is incorrect. So if you see the options, so D is not our option, so we are left with only C. So if we mark this answer, so C is our answer. So allocation of financial resource to ministry is done by the Ministry of Finance. This is a responsibility of Ministry of Finance, not a cabinet secretariat functions. Clear? So this is the questions, and this question basically is more about the factual questions. So for this, you should knowing the fact about the cabinet secretariat and central secretariat. Now let's see functions of a cabinet secretariat. How we can say that the first and second statements are correct and the third is incorrect. So let's see the explanations to this. So if you see the explanations to the given, so it says that the cabinet secretariat plays a crucial role in ensuring the smooth functioning of government of India by facilitating decision making at the highest level. Highest level, as we know that the cabinet is a highest deliberation body. This is a body at which all the policies, plans, laws were finalized by the government, and then after the uh, assurance or passage or finalized by the cabinet, then it is the policies and plans or laws will be introduced in the house, right? So government at the cabinet level, they deliberate in very holistic manner. So to assist them, there is a cabinet secretariat which facilitating the decision making. Now if you see the its function, so its function has been bifurcated under different heading. So first says that facilitating decision making in the cabinet and committee. So it prepares the agenda for cabinet and cabinet committee meeting. So what agenda is to be discussed under the meeting, what should be its key point, and all that has to be prepared by the cabinet secretariat, right? And all those will be distributed to all the cabinet ministers. Provide secretarial assistance during these meetings, including recording minutes, is issuing directives and ensuring flow up follow up action. So all these were performed by the cabinet secretariat. They prepare the plan, they take follow up, they help the cabinet ministers in deliberations and during the cabinet meeting. Second is a coordination between ministries. So they act as a chief coordinating agency in resolving interministerial difference. So whenever there is an interministerial, when there is a difference between the one ministry and the another ministry, so it is a cabinet secretariat who resolve this or who try to resolve the differences between the ministries. It ensures consistency and coherence in the policies and programs of various ministries and departments. So this is also one of the functions. Next is communication of decisions. So they communicate the decision of the cabinet to all relevant ministries and ensures their implementations. They monitor progress on the executions of decision taken in the cabinet meeting. So this is they act as an observer also, we can say that. Right? They observe that whether the decisions which has been decided or which has been discussed in the cabinet or taken in the cabinet that has to be reached to every ministries, and in their implementations also, that the decision should be implemented very effectively. They also act as a policy supports. So they provides informations and analysis to assist the cabinet in formulating policies. They ensures the policies are implemented in accordance with the government directives. So whatever the government directive is, so it is a responsibility of the cabinet secretariat to ensure this directives while implementing the government policies. Crisis management, they plays a role in managing national emergencies and crises by coordinating with different ministries, departments, and agencies. Next role is management of rules of business. So they administer the government of India transaction of business rules and allocation of business rules to ensure efficient functioning of the government. They provide support to prime ministers, provide direct support to prime minister in the discharge of their functions, particularly concerning cabinet meeting and policy issues. Then next is administration of secretariat of appointment committee of the cabinet. So deals with high level appointment in government ministries such as public sector undertaking. So they are the responsible for appointment of ministries, appointments of head of the ministries, appointments of administrative head in the ministries like deputy secretary, principal secretaries, or cabinet secretary. Anything that is to be decided by the cabinet secretariat. So cabinet secretariat provides secretarial assistance to cabinet committee, including preparation of paper, circulation of decisions, and ensuring follow-up actions. So we can say that given the first two statement, that preparing of agenda for cabinet meeting is an policy, is a functions of cabinet secretariat, and secretarial assistance to cabinet committee is also one of the functions of cabinet secretariat. But allocation of fund is not a function of cabinet secretariat. So we can see here for the explanations of allocation of finance, it said that the allocation of financial resources to ministries is responsibilities lies with the Ministry of Finance, particularly the Department of Expenditure during the budgetary process. So it is a Ministry of Finance and particularly Department of Expenditure who is responsible for allocation of budget or financial resource to the ministry. So all, as we know, that all ministries, they prepare their own budget and submit to the this Ministry of Finance and Department. Then through the Finance Ministry, they combinations with this, they prepare a demand for grant, and once the Parliament through appropriation bill authorize the government to withdraw money from the consolidated fund of India. Then after withdrawing money from consolidated fund of India, the Ministry of Finance distribute the budget according to their demand of grant of the departments of ministries. Clear? So this was question 11, and that was asked in 2014. Now moving to the next questions. So the next questions was asked in 2013. Let's see, the question says, which one of the following statement is correct? So let's see, we need to find the correct statements. So first is, in India, the same person cannot be appointed as a governor for two or more states at the same time. It is incorrect. Originally, if you see, the originally there was no such provisions. There was no such provisions in constitutions. No such provisions under Constitution of India with respect to a same person appointed as governor for two or more states. But through the 7th Constitutional Amendment Act in 1956, when the state reorganization, through which the state reorganization bill was introduced, so through this Amendment Act, the changes was made into the governor appointment under Article 153, which says that a same person can be appointed. So this has made changes. This has made changes in the changes in Article 53 through the 7th Constitutional Amendment Act 1956, which says the same person can be appointed a governor of two or more states. So this statement is incorrect in present scenario, but if it talk about original constitution, there was no such provisions. Now if you see the second statement, so this cannot be our answer. So if you see the second, the judges of high courts of the states in India are appointed by the governor of the state, just as the judges of Supreme Court are appointed by President. No, this is also incorrect, because the judges, whether it's being a Supreme Court judge or High Court judge, they are appointed by the President of India, not by the governor. High Court judges were not appointed by governor. So this is also incorrect, and this is very common option. So easily we can find that this is incorrect. Now if you see the third statement, that no procedure has been laid down in the Constitution of India for removal of governor from his or her post. Whether this is true or not. So as we know, if we see the related to the governor, so as we know that the governor, along with the Attorney General for India and individual ministers, union ministers, particularly union ministers, So all these three offices comes under the pleasure of president. Pleasure of president. It means the president can remove them any time. It means when we talk about the pleasure of president, so it means that they can be removed by president anytime, and without any ground. Without any ground. So they may be removed by the president, and that's why for many a times we see the reshuffle of ministries. So in reshuffle, whenever the government do a reshuffle, it means it may be a ministry may be changed, or some new ministers may be included, some new member may be included into the ministry, or the ministries or the old minister can be removed from the ministries. So this has been done under the by the president, though it is not a discretionary of president. It is to be done on the advice of council of minister, but due to this they are known as a pleasure of president, because there no procedure has been laid down in the removal related to governor, attorney general, or individual ministers. Clear? So this statement C is correct, right? If we go through, but if we check the for the correct answer, we need to check the this D also. So let's check the D options. In the case of union territory having a legislative setup, the chief ministers is appointed by the lieutenant governor on the basis of majority support. So talking about the UTs with legislative setup, that is meant Delhi, Puducherry, and the recently added is Jammu and Kashmir. So the chief ministers on a majority support is appointed by lieutenant governor. No, this is also incorrect. They are being appointed by the president, similarly to that of an union, and the individual ministers in UT also lies under the pleasure of president. Unlike the ministers of states, unlike the ministers in state, so ministers in states are under pleasure of governor, not under the pleasure of president. So this is also incorrect. So our correct statement answer is C. That is, there is no provision has been laid down under the Constitution of India for the removal of governor from his post, and because of this, the governor is come under the pleasure of president. Clear? So let's see the explanations to the given options. So if we see, so Article 153 of the Constitution that talks about a governor of state. So there shall be a governor for each state. This is a mandatory provisions that the state cannot be a without governor, provided that nothing in this article shall prevent the appointment of same person as a governor for two or more states. This was added through the 7th Constitutional Amendment Act, and the Constitution has a provisions that the same persons can be a governor for two or more states, or it also can be a at the same time can be a governor of two or more states plus a LG of UT also. So governor persons can be given an additional charge of an UTs. So on the basis of Article 153, we can say that this is incorrect. Now if you see the Article 124 that talks about an establishment and constitutions of Supreme Court, so it says that according to Article 124 clause 2, every judge of a Supreme Court shall be appointed by president by warrant under his hand and seal on the recommendation of National Judicial Advisory Council referred to, and shall hold office until they attain the 65 years age. And this is thus similarly applicable to the High Court judges also, right? So next if we see, so on the basis of this also we can say the B is incorrect. Now if we see the term of office of governor, Article 156, so Article 156 says that the governor shall hold office during the pleasure of president. The governor may, by writing under his hand address to the president, resign from his office. Subject to the foregoing provisions of this article, a governor shall hold for a term of 5 years from the date on which he enter upon his office, provided that a governor shall notwithstanding the expiration of his term, continue to hold office until his successor enter upon his office. So these are the term of office. So the first clause of 156 says that the leave it comes under the pleasure of president. It means there is no provisions has been mentioned under Constitution of India that how a governor can be removed from his office. So according to 156 article, this is true or correct statement. Now if you see this, for the third C, according to Article 239 AA Clause 5, the Chief Minister of UT of Delhi shall be appointed by the president, and other ministers shall be appointed by the president on the advice of chief ministers, and ministers of UT shall hold office during the pleasure of president, similar to that of union ministers. Clear? So on this basis, this is also incorrect. So if you see this explanations in union territories with a legislative assembly, Puducherry, the chief minister is also appointed by president. So in case of Puducherry also, it is appointed by president, not by the LG, based on the majority support in legislative assembly. The lieutenant governor plays a significant role in governance of UTs, but does not directly appoints the chief ministers. So chief ministers and ministers in the UTs having a legislative assembly appointed by the president, similarly to that of an union government. Clear? So answer to this question is C. Now let's move to the next question. So the next question was asked in 2013. So it said, let's see the question. So it says that consider the following statement. That statement is about Attorney General of India. So Attorney General of India can take part in the proceeding of Lok Sabha. Yes, he can take part in the proceeding of Lok Sabha. Be a member of committee of Lok Sabha. Yes, he can be a member of committee of Lok Sabha. Speak in the Lok Sabha. Yes, he can speak in the Lok Sabha. Vote in the Lok Sabha. Do the Attorney General has a power to vote in the Lok Sabha? So to answer these questions, we need to understand who can vote in a house. So to vote in any house, the person has to be a member of particular house. The person has to be a member of particular house, right? So is an Attorney General for India is a member of the house? Is member of house? Either of the house? No, he is not a member of either of the house. So if he being a virtue that he is not a member of the house, so he has no right to vote in Lok Sabha nor in the Rajya Sabha also. And also he cannot vote in any parliamentary committee to which he is a part. So he cannot vote in any committee also to which he is a part. So fourth cannot be our answer. So this cannot be our answer and this cannot be our answer if we go through the elimination method, and 1 and 2. So our answer is 1, 2 and 3, that is C is our answer, whether he can be take part in the proceeding of Lok Sabha and Rajya Sabha also. He can be a member of committee of the Lok Sabha and Rajya Sabha also. Yes, he speaks in Lok Sabha and also he can speak in the Rajya Sabha also. So to answer this question is C. But to vote in any house of the parliament, he has to be a member of the house, particular house, then only he can vote, right? Now to understand more elaborately this, if we see that a member of Lok Sabha, like any minister who is a member of Lok Sabha, so he can speak or take part in a proceeding, in Rajya Sabha, but cannot vote in Rajya Sabha. Why? Because he is not a member of Rajya Sabha. So even a member of Lok Sabha can take part in proceeding of Rajya Sabha, can speak in the Rajya Sabha, but he cannot vote in the Rajya Sabha or in the other house because he is not a member of that house. And because on the logic of this, so we can say that if a prime minister who is a member of Rajya Sabha can only answer the allegation under no confidence motion against his government, but he cannot vote in no confidence motion. Why? Because no confidence motion comes and under the control of Lok Sabha, and he is being a member of Rajya Sabha, he cannot vote in the other house. So he can only answer the allegation against his government under the no confidence motion, but he cannot vote in the no confidence motion because on this logic. So to understand this logic, we need to understand that to vote in either of the house, the person has to be a member of that house, and Attorney General is not a member of the house, and Attorney General is also not a any service under Government of India. Clear? Now, if you see the explanations to these questions, so Article 88 talks about the rights of ministers and Attorney General as a respect house. So every ministers and Attorney General of India shall have the right to speak in and otherwise to take part in the proceedings of either house or any joint sitting of the house and any committee of the parliament of which he may be named a member, but shall not by virtue of this article is entitled to vote. So he or either of the member who is not a minister, who is not a member of the other house, so he, other than the right to vote, he has all other rights to speak, to take proceedings in the house or to any committee, but he cannot vote in the house to which he the person is not a member. Clear? So this was a question asked in 2013. Let's move to the next questions. So next question was also asked in 2013. This is also asked in 2013. Let's see the questions. Consider the following statement. So the three statement is given, right? And we need to find the correct answer to these questions. So let's see the first statement. The Council of Ministers in the center shall be collectively responsible to Parliament. Let's talk about the Council of Ministers, and we know that the parliamentary form of government. So one of the major feature of the parliamentary form of government is that executives being responsible, right? This is a parliamentary form of government, but it talks about the Council of Ministers in center shall be collectively responsible to Parliament. So they are not collectively responsible to Parliament, but they are responsible to lower house or Lok Sabha, or as we called a House of People. House of People. Clear? So this, the first statement is incorrect, right? So if we go through the elimination method, so 1 cannot be our answer. It means A cannot, 1 is not an option, so A is not an answer. C and D cannot be our answer. So through elimination method, we can mark our answer as C, but we will see the second and third. So without going to second and third statement, if we are in very comfortable positions, conceptually, if you are strong, so you will be in a position to find the answer only just going through the first statement. If you find that first statement is incorrect, so you easily derive the answer. But let's see the both the statements. Union minister shall hold office during the pleasure of president. Yes, this is true that they are been under the pleasure of president according to article 75 clause 3, and we have also seen that the governor, recently we have seen the governor, individual ministers and attorney general of India all comes under the pleasure of president. It means when we talk about a pleasure of president, so it means two things, that their procedure and manner and grounds are not mentioned for their removal in the constitutions. So second is true. The prime minister shall communicate to president about the proposal for legislations. Yes, this is also true. So according to article 78, prime ministers, PM, acts as bridge between president and his council of ministers, or and his ministries. Right? This is a responsibility of PM, and also the Constitution has provided responsibility of PM to inform the President about the functions of all the functionaries of his government. Why? Because President is being a head of executive. So as a head of executive, though he is a nominal executive, he has a responsibility to know what his government is functioning and what his government is up to the in parliament, whether which law has been the has been introduced by this government. So it is a responsibility of the prime minister according to article 78 to inform the president about his functioning of or any proposal of this legislations. Clear? So this is also, you can say, that correct statement. So our answer to this question is B, that is 2 and 3 is correct statement. If we see the explanations to this constitutional explanations, so for the first statement, according to Article 75 Clause 2, the minister shall hold office during the pleasure of president. This was the second statement is true on this line, that they hold office during the pleasure of president. The 75 Clause 3, Article 75 Clause 3 talks about the Council of Ministers shall be collectively responsible to the House of People. So they are not collectively responsible to Parliament, they are not responsible to Rajya Sabha, but they are responsible to Lok Sabha. Why? Because Lok Sabha is directly elected by the people, a representative directly elected by people. Whereas Rajya Sabha has an indirect elected members, like elected members into the Rajya Sabha. And because of this, the Council of Ministers or ministries are responsible to House. It means through House of People, through responsibility of Lok Sabha, the ministries are indirectly answerable to people of India. And as we know that the people of India are supreme authority in the India. So this is the people of India who empower the constitutions, give power to constitutions, and constitution empowers all the functionaries and organs of the government. So to become to be a responsible to people, Lok Sabha is responsible to, legislature, cabinet are responsible to Lok Sabha, and through that Lok Sabha they are answerable to people. Clear? So on this uh, article, according to Article 75 Clause 3, this is incorrect. Now if we move to the next explanation, that is for the third. So Article 78 talks about the duties of prime ministers as respect the furnishing of informations to the president. So it says that it shall be duty of prime minister to communicate to president all decisions of the council of ministers relating to the administration of affairs of union and proposal for legislature. Second, to prime minister to furnish such information relating to administration of affairs of the union and proposal for legislation as the president may call for, and if the president so requires, to submit for the consideration of council of ministers any matters on which a decision has been taken by a minister but which has not been considered by the council. So third says that if any decision or any advice tendered to tendered to president, and that advice is tendered by minister, individual minister, not by the council, so president can return that advice for the consideration of council once, and after council return, after reconsidering the advice tendered, is an mandatory on the part of president to follow the instructions or advice. Clear? So this was asked in 2013. Clear? Let's move to the next question. So next question was asked in 2012. This is related to the, so let's see the questions. According to the Constitution of India, so now it is talking about according to Constitution of India, so we need to stick to ourselves to Constitution of India. it is a duty of the President of India to cause to be led before Parliament which of the following. So basically this is asking a power of legislative, one of the legislative power of President, that which report does he put in the Parliament for discussions. So first, does he put a report of recommendation of Union Finance Commissions? Yes, because Union Finance Commission is appointed by President. So Finance Commission submit its report to President, and then President submit its report to the Parliament for the discussions. For the discussion. So this is true. So first is true. So this cannot be our answer because it does not contain the first statement. So this and this. Let's see the next statement. Reports of Public Account Committee. So does it is a responsibility, does it is a duty of the President to lead before a Public Account Committee? So as we know that the Public Account Committee is a standing committee of Parliament, right? And it is one of the committee under the financial committee, along with the estimate committee and public undertaking committee. So the being an parliamentary committee, it is constituted by Parliament to scrutinize the expenditure of government, and after scrutinies made by the pack of a government, the committee directly submit its report to the Parliament. So it is not given to the President but directly submitted to the Parliament. So this report, Public Account Committee report, is not been submitted by or led before by the President of India. So second is not an answer. So this is not an answer. So D cannot be our answer. Now let's see whether third and fourth can be answered or not. A report of Comptroller and Auditor General, CAG. Yes, this is also true. Why? The same logic that CAG is appointed by President. So CAG will submit its report to the President, and then President will let this report into the Parliament. So this is also true. So our answer to this question become C. And if we see the third also, the report of National Commission for Scheduled Caste. So this is also appointed by President. So they will submit their report to the appointing authority, which is a President, and then President will let this report into the House for its discussions. So answer to this question is C, 1, 3 and 4, and second is not the correct. Why? Because this is a parliamentary committee, and this parliamentary committee, so they will submit their report to Parliament. So if you see the explanations to these questions, so there are certain reports tabling various reports before Parliament by the President. So these are the reports which is tabled in the Parliament by President. So first is annual financial statement, that is budget. Next, audit general relating to accounts of Government of India, that is CAG report. Recommendation made by the Finance Commissions. Report of UPSC. Report of Special Officer of Scheduled Caste and Scheduled Tribes. Report of Commissions on Backward Classes. Report of Special Officers of Linguistic Minorities. So all these reports were submitted by the President. But the Public Account Committee, and on the logic of this, we can say that the first, third and fourth is correct. So if you see for the second, the Public Account Committee is a parliamentary committee. Its report are not presented by the President but are tabled in Parliament by Public Account Committee itself. So this is not a correct statement, and this the report of Public Account Committee submitted to the Parliament directly by the committee itself. Clear? Moving to the next questions. So this question was asked in 2012. 12. Let's see. The Prime Minister of India at the time of his or her appointment. So this is about a Prime Minister of India at the time of his appointment. And we know that the Prime Minister is appointed by President. So in India, the Prime Minister is not. So if we talk about the India, the Prime Minister or Chief Minister. So through this questions, we can also understand this will similarly applicable to Chief Minister also. So here we can say the Prime Minister or Chief Minister is appointed. They are not elected or selected or nominated. Rather, they have been appointed, and the appointing authority of a prime minister is president, and appointing authority of chief minister is governor in the state. Clear? Now, to whom the president will appoint as a prime ministers? So the leader of majority party, or we can say that the party who has secured the majority seats, that is an absolute majority seats in the parliament, or especially to the Lok Sabha, right? So the leader of that party will be appointed as a prime minister by the president, and appointing of a president is sometimes known as a discretionary of president. Clear? When it becomes a discretionary, when there is an hung parliament. Hung parliament. Right? Hung parliament. This is not always a discretionary, but sometimes when there is an hung parliament, so it is a discretionary of president that he can call anyone to be appointed as a prime minister and asked him to prove his majority in the house. So in case of hung parliament, and hung parliament is situations when no political party secure absolute majority in the Lok Sabha. So in case of no absolute majority in Lok Sabha, so that becomes an hung parliament. So in the case of hung parliament, the president may call anyone to prove his majority by appointing him the prime ministers. Clear? So that becomes a discretionary power. Now let's move through the options. So the first option says the prime minister need not necessarily be a member of one of the houses of the parliament, but must become a member of the one of the house within a period of 6 months. Yes, it is true, as we know that the outside, according to Article 75, the outside person may be appointed as prime minister even if he or she is not member of either house of parliament, but within a period of 6 months the person must become member, either by election or by nominations. So there is no restrictions that only through getting elected he should be a member. Through nomination also, if he become a member of either house, so he can be a prime minister. And this can be seen many a times in the recently, if we see the Bengal elections, where the chief minister of Bengal, Mamata Banerjee, lost her seats, but still she was been appointed as a chief minister. Why? Become the provisions under the constitution that outsider can also become a ministers, even the prime minister or chief ministers, but within a period of 6 months the person has to be a member of house, either through election or through nominations. So this is true. Clear? So the very first option is true. So we can say that this is our answer. But if you see the second, third and fourth, why it is not true? So if you see, so it says that need not necessarily be a member of one of the houses of parliament. This is the similar to that of the first, but must become a member of Lok Sabha within a 6 month. No, not only to Lok Sabha. If a person become a member of Rajya Sabha also, that can also be a member. So because of this term Lok Sabha, the second is incorrect. Must be a member of one house of the parliament? No, it is not necessary that he must be a member of. He can, even the member, even if the person is not a member also, can also become a prime minister. Must be a member of Lok Sabha? No, this is also not. There is no such conditions that only a member of Lok Sabha can be appointed as prime ministers. A Raj Sabha member can also be appointed as a prime minister, like our former prime minister, late Dr. Manmohan Singh. Clear? So answer to this question is A. The very first answer. If you see the explanations to this, so it says the constitutions does not explicitly state that prime minister must be a member of either house of parliament at the time of appointment, but according to article 75 clause 5, which says that if a person who is not a member of either house is appointed as prime minister, they must become a member of either house, either to the Lok Sabha or Raj Sabha, within a period of 6 months. If they fail to do so, they must resign from their office. So if they do not become a member, so they have to resign from this office. Yeah. So this is all from the executive sections, which includes the state executive and union executive. Hope you enjoy the this videos, and hope it's also help in your preparations. So do like, share, and comment in the video how you like it, or whether you like more explanations, want a more explanations on any topic, or whatever the topic has been left according to you. You can comment also, but please like and subscribe to the channel also, because this the analysis of the channel shows that the viewers are more who are not subscribed to the channel. So I'm requesting you to subscribe this channel, and also ask your friends to subscribe and to do watch the channel. Thank you and good luck.